neither permissible nor warrantable. There are certain fixed canons of construction and interpretation of statutes and the High Court finding as regards the office of the competent authority requires. But this is a principle. Now, another one judgment. But then my submission would be that to this limit, that it has to be read, it has to be, it will be done, it will be on the basis when the intent list will be prepared.
All right. Yes. Yes.
When we interpret a rule, the first thing we find out that there is no challenge to it. First, if there is a challenge to the rule, then the parameters are completely different. Whether it exceeds the legislative power.
Please do not make this submission. That is not the issue.
Right. Now, today, your lordship is invited to look into or adjudicate as to at what stage the marks for prior teaching experience are to be given. Number one is prior teaching experience. You need to look into the object of inserting a prior teaching experience as one of the qualifications. And where a rule also permits people who do not have the prior teaching experience to participate or offer their candidature election process, obviously they are in a separate company. So prior, it's not like the promotional rules from post A to post B. You must have say prior teaching experience of say 5 years. Which applies to all the candidates.
Merit comes seniority, seniority comes merit.
Now, here is a case where your lordship would find two categories of person offering their candidature in the same process. And prior teaching experience fetches a few more marks to persons who have the prior teaching. The purpose is, what would be the purpose? Because your lordship is dealing with the rule will not emphasize this, will not effectuates the broader aspect that is not Article 21A of the Constitution. Because this rule is confined to the upper primary level of classes, that is classes 5 to 8. They will not Article 21 fundamental. Therefore, these rules what we.
Sir, why don't you sit? Please give him a
no
chair.
place to sit. But I can sit on the lap of it.
He doesn't want to sit.
No.
He says, I'm
Sir,
a
please
permanent
sit.
standing counsel.
Please give him a seat. No, no, please. Sir, it will be very improper if you stand. Please sit.
Yes.
Please sit.
আমার বিকাশে কোলে বসতে হতো আমার।
Now, my lord, the dominant aspect or the broader aspect or the more important aspect, my lord, is what, my lord, we all lose sight of. Is this rule framed only for the purpose of selection, or it has a larger aspect in it, embedded in it, which is to offer or effectuate the fundamental rights of children between 6 to 14. And Article 21 and the follow-up legislation, that is the Right to Education Act, Millard provides that quality education has to be provided to those children of that age group. Now, please keep, Millard, these two aspects in mind, Millard, for the purpose of interpreting the juncture at which, Millard, this prior teaching experience marks are to be awarded. First is, what is the purpose of inserting this kind of a clause? The purpose can be nothing else than to, my lord, provide or ensure that better quality candidates are selected. Now, how do you distinguish broadly? Inter-se merit is something different. But broadly, we distinguish between, for example, take a hypothetical case not related to this matter. In a case where, say one group high secondary candidates, past candidates apply, and another group, secondary candidates apply. There, logically, if somebody says that no, I will consider the high secondary examinees or past candidates as better or in a higher pedestal than the secondary candidates, but that, in my very respectful submission, is a logical approach. But merit-wise, maybe the secondary candidates may outshine the high secondary past candidates. So therefore, the purpose of providing this clause is to ensure that more experienced persons or persons who have teaching experiences are put in a better place for the purpose of selection. Why? Why is this incorporation? To ensure that better teachers are tried to be made available. Finally, who's good, who's bad is again something a matter of perception, performance, many other unknown things. So this being the purpose, now Millard kindly read the rules. But we cannot read this rule only to confine it to selection or confine it between the inter-se merits between the prior and persons having teaching experience and persons not having teaching experience. Now please take Millard 2K, I'm sorry. But your lordship must have read this rule many times. Now, interview list means etc. in the post of so and so, a list of candidates to be called on merit for oral interview and lecture demonstration category wise on the basis of preliminary merit score. So when I call people, I first prepare a preliminary merit score. Now I have to distinguish. Here, I should be the school service commission, be that as it may. So I have to distinguish between the more experienced, I call it the preliminary, teaching experienced people, and the others who do not have the teaching experience. Therefore, at the preliminary score assessment stage, I have to take into consideration the merits of those persons, or I have to take into account those persons who have the prior teaching experience. Now, why I say this? Because what is the purpose? You have to look into the purpose also, because...
No, you are going around the same thing all over again.
Yes.
What is the stage? 10 marks, we take it that yes, you can give, because right now we are taking it to 2025 rules as a whole, assuming that it is all right, challenges before the Supreme Court, this is not the issue here, the court is not deciding. At what stage will this 10 mark come?
Preliminary merit score.
Yes. Where from are you getting that the 10 has to be added earlier and not later?
Please take rule number 6.
Rule number 6.
Yes, your lordship must have been taken through these.
No, 6.
Yes, I'll come to the schedule.
No, it's all right. Rule number 6.
Rule number 6 says manner of selection. Selection shall be made category-wise on the basis of merit in the manner as specified in Part A of Schedule 2. Now let us come to Part A of Schedule 2.
Yes.
Which is page 89.
Yes.
Millard, Schedule 2 Part A has 4 parts. All these Millard, the first part is written examination, which is based on OMR sheet marks. Then 2 is academics. Now this academics, Millard, has been divided into 2 parts. That is educational qualification 10 marks and prior teaching experience 10 marks. Those who are not having prior teaching experience, for them B doesn't apply. Then is the oral interview and then the lecture demonstration. Now, Millard, based on this, Millard, prior teaching experience is part of the educational qualification which is provided under the rules. Therefore, prior teaching experience marks is part of the academic marks that a person is to have.
How do you say that it is provided within the group broadhead academics?
Yes, Millard, one is written examination,
Yes.
two is academics. Now, what is academic? Academic has two parts. These two parts are applicable in respect of two categories of person. If a person has prior teaching experience, then into A and B applies.
Submission has been made to this extent
Yes.
that the word here in Schedule 2 is academics. It's S.
Yes,
S,
yes,
plural.
yes,
In K,
yes,
it is mentioned only academic. The
Yes.
S is not there. And this S
yes,
considers the teaching experience, which is there in the schedule. It is not there in K.
yes.
So,
But are my learned friends suggesting that this is plural and the other is singular?
right, it
Millard,
is.
Millard, general clauses act, Millard. Singular includes plural, plural
Very well.
includes singular.
If that is to be
Yes.
taken, then K and L will be contradictory.
I'll come to that. I'll come to
Yes,
I'll
please.
come to that. Therefore, let us, Millard, first clear the air that in academics, is academics only confined to educational qualification, or academics will also include prior teaching experience for
Right.
those who have the experience?
Yes.
Well, my very respectful submission is, unless Millard Schedule 2 is challenged on XYZ grounds, Millard, the Schedule 2 as it is to be read, which means that prior candidates having prior teaching experience has twofold academic qualification, if I may put it broadly, and candidates without teaching experience have only one part of the experience under academics.
All right.
Now,
Now-
kindly come back to Millard, Rule 2K.
Yes.
But I don't think, Millard, academic and academics would make much of a difference. One single alphabet will.
রাহুল বলছে যে এখানে আগে অ্যাডজেক্টিভ ইউজ করেছে আর ওখানে আগে নাউন ইউজ করেছে এখানে অ্যাডজেক্টিভ করলে এটা ভুল হয় ইনটেক্ট এরার হয়
I'll hear you.
Hmm.
Do you also have a seat over there? Please sit. Please sit. Yes.
Now, academic score in clause K is nothing other than, Millard, the academic score spelled out in Millard Schedule 2, Part A2. Let us not go into all these things, but whether with S and without S, it at all make any difference. But
S means the prior teaching experience.
yes,
Without S is only the educational score.
but in that case, please consider one thing, Millard. What happens to the persons who do not have the teaching experience?
They don't get the marks.
They don't
either
get
at
the
this
marks.
stage or that
Yes.
stage.
Therefore, the stage is, Millard, when, Millard, I call them for interview, I have with me the marks which they are also entitled to by virtue of their experience. That is the purpose. If I exclude these people at the threshold by treating everybody equally, what
At
they,
par.
yes, at par,
Level playing ground. This is the
Millard,
That
level
is
playing ground, in my very respectful submission, this may not be applicable universally, because preferential treatment is acknowledged and applied in the service jurisprudence.
yes. All right, then
Therefore, Millard, if I give them these trained persons or the experienced persons, I go a bit forward by saying that I give them a preferential treatment by adding their marks at the time of preparation of this preliminary merit score but I would be respectfully submitting that is not infraction of any of the known principles of our constitution or the law of our country. Therefore, my lord, if a person is experienced, my lord, the experience has to be taken note of before calling them for interview and lecture demonstration. Now, the interpretation should be as I say. Why? Because if I do not give them, because it is said, please look into the bracket portion. It is clarified, that is, from the written test or TET and academics score. Now, what they are trying to say is that academic and academics are different. Well, with respect, possibly it doesn't make any difference. Yes.
It makes a whole lot of difference.
No.
It makes a whole lot of difference, sir. This is the 10 marks issue is there in many matters. Madam, please sit. Please sit. I'll hear you. And now the stage at which it should be added.
2K. This is my interpretation. Now let us come to 2L.
Yes.
Yes. Merit list in respect of SLST so and so means in case of post a list of candidates prepared category wise on the basis of merit, which shall mean in addition to what has been stated in 21K, marks obtained in oral interview, lecture demonstration and prior teaching experience, and shall include all eligible candidates who have appeared in the interview. Therefore, Millard, the prior teaching experience over at Millard L, Millard, if it is held or if it is interpreted to be at the L stage and not at the K stage, then Millard, it militates against Millard Schedule 2A2. And 6. But the rule by itself, the purpose of the rule is to give preference to the experienced candidates.
You give preference.
Yes. Therefore,
but then at what stage will you give?
Millard, if I give them preference, I need to give them preference at the first stage or at the earliest stage. Because preference, the word preference itself presupposes that from the very beginning I'm going to separate both the classes.
Resources will not be augmented appropriately.
Yes. But preference cannot be Millard at the end. Preference has to be always Millard at the beginning.
Do you anticipate any candidate
Yes, ma'am.
who did not participate in the 2016 recruitment process to get this 10 marks?
More than 3,000 people have applied.
More than
3,000 of central government and more than 1,000 for the contractual teachers of substantive posts in state government. More than 4,000
have applied.
3,000 plus 1,000.
3,000 which is central government.
Central government and 3,000.
No, the figures, I do not know, Millard, whether it will correct or not, but Millard, I am instructed to say
I do not need the exact
Yes.
figures.
approximately 3,000 candidates with prior teaching experience from central government institutions, schools, etc. have applied, and 1,000 from
State government has provided a list of contractual teachers and substantive post of 1,000 teachers.
and contractual teachers
In substantive post
in substantive post in state government institution around 1,000.
applied.
They have
And
applied.
the total appointment is around 23,000 or how many?
35.
35,000. All right.
Very well, 35, 36 more or less.
Hmm.
Therefore, Millard, if I have to give preference, well, there are two ways of interpreting it. What is the purpose? If the purpose is to make available good teachers, I have to give them preference at the beginning. Number two is, as they are arguing that this is creating a class between the two. Yes, we are creating a class.
No, the class is not in this matter.
The other,
Class is in
very,
classes
then Millard,
right. Class
yeah,
is
I don't,
not-
I don't,
We assume that the rule is all right.
very well.
It is only the stage at which the 10 marks to be allotted is the issue.
First, to make available good teachers for the students.
In that stage also.
Yes.
Stage also you can make available good teachers.
No,
Because you
no.
are adding at any case.
Milord, I am giving a preferential treatment, therefore preference has to be given
At the very first stage.
at
This
the-
is
at the
the
inception.
main submission.
at the inception.
That is the submission.
Then what is the purpose?
Milord, if Milord, the experienced candidates are Milord screened out or Milord,
Why will they be screened out? Because they will get the chance at that level also.
if
Nobody is screened out at the
One is issue.
2 case stage.
No.
Issue আছে তো।
kindly look into Milord the interview list.
Yes.
Milord, in the interview list, if Milord these 3,000 or 4,000 are not there, and they have to wait, Milord.
Why will they not be there? That means their educational qualification score must be less. Otherwise, they
No,
would
no.
have been there.
Milord, today, Milord, at the time of framing of the rules, or Milord, at the time of invitation or the advertisement or the employment notification, I do not know anybody's score.
Nobody knows anybody's
Yes,
score.
therefore, consider it from the stage or at the stage when Milord,
Yes.
an employment notification has been issued.
Right.
There, nobody is in the fray.
Nobody is in the
Nobody has applied.
right.
We do not know the inter se merits of the candidates. At that stage, what should be the appropriate interpretation? Milord, the interpretation should not be, Milord, at the instance of persons who come before the court, invoke the jurisdiction of the court, saying that I don't have the experience, therefore I'll be in the back seat always. That is what is being said. Now, consider this, Milord, on two angles. One, I have already said, for the benefit of the students. The other is, at the selection stage, I have to give preference or priority to those persons who are already experienced. The experience factor has to be taken note of at the earliest stage. It may, Milord, even be relegated back to, Milord, from the date of application itself. Because on the date of application itself, there are two, submission of application, or the last date of submission of, you have two sets of people. I can do that at that stage even.
I didn't get this. I didn't get this.
Yeah, I'll tell you, I'll explain it, Milord. I invite application. 10,000 people apply. All the applications are with me. I have invited two categories of persons. Can I not distinguish between the experienced and not non-experienced persons at the very threshold after receipt of the applications? General, I'm speaking of general, hypothetically. Not Milord, connected to this case.
No, when you seek application, you seek application from all.
All
There, what you say that there will be a distinction between the
no,
candidates
I will invite applications from all.
open advertisement.
All applies,
Yes,
or two categories of people apply.
right.
Can I not give
Two categories means what?
with teaching experience, without teaching experience?
All right.
Now, at this stage, this is hypothetical, not as
Yes,
per
yes,
this
yes,
rule.
yes.
At that stage, after receipt of application, from that stage itself, Milord, the preferential treatment or the preference starts.
Provided your advertisement specifies so, it has to
I mean,
specify.
advertisement may or may not be. Finally, the rules prevail. In case,
That means the ruals, whatever, you should have
Yes,
a substantive rule
yes,
according
the-
to which
yes.
you can say.
My reading of the rule is that the teaching experience has to be given at the time of assessment of the preliminary merit score.
এটা সুপ্রিম কোর্টের যে order টা।
All right. Yes, madam.
Yeah.
Just one.
Yeah, just a minute.
Just
You
I just
want to
answer
make
the
more
Sinha.
submission?
just
No,
one minute.
I think Mr.
Just
Bandyopadhyay
one
has
minute, just one
Can I
minute.
just
Just
answer
one
this
minute,
or
just
can
one
I-
minute.
I'll hear you.
The 5th August, sorry, I missed it. 5th August, Supreme Court has passed an order in the review petition. In that review petition, the Supreme Court has said the entire selection therefore had to be invalidated to maintain the sanctity of the process of selection, which should be pristine and free of all such inferior. However, the interest of the appointed candidates who were untainted were sought to be protected to the greatest extent possible, as is evident from the concluded paragraphs of the judgment.
Hmm.
Greatest extent here means that this has to be protected. Now, this is the experience part is also there.
5th of August.
Pardon?
5th of August.
5th of August. 5th.
Supplementary affidavit has been filed as 5th.
Spiral compilation.
1 minute. 5th of August order is there.
Yes. Page 281. It's the spiral compilation. 281. 281.
Which portion did you read?
My lord, this is at paragraph 4.
Paragraph 4.
Paragraph 4, last few lines, above
Yes,
paragraph.
the adverse remarks.
The entire selection, therefore, had to be
The
invalidated.
entire selection. Yes.
Therefore, had to be invalidated to maintain the sanity of the process of selection. We should pristine and free of all such information. However, the interest of the appointed candidates who are untainted were sought to be protected to the greatest extent as possible, as is evident from the concluding paragraphs of the judgment. No doubt, invalidation of such untainted appointments would lead to heartburn and anguish, which the court was fully conscious of. But protecting the purity of the selection process is paramount and necessarily has to be given the highest priority. Last but not the least, the adverse remark made against the authorities concerned who are wholly and solely responsible for the adverse appearances of kind of until were fully warranted and justified. Now, the protection, this is
Whatever is protected is protected. That nothing.
But,
Supreme Court has not given you anything else.
Here has not been clear, but this
Goes against you rather.
Protection to these 10 marks which have been given.
You give protection, but at what stage is the issue now?
Now, may I just take you, my lady, back to
Yes.
Schedule 2.
Schedule 2.
My lady's question on academics and academic score,
Yes.
singular and plural.
Right.
Now, this is only English grammar. How are you in academics? Means English, math, so on and so forth. What is your academic performance? What is your academic score? That is the only
Tell
distinction.
me one thing. How are you
Yes, ma'am.
interested in this matter?
No, I am in 4 IAs before you,
Yes.
untainted candidates,
Maybe.
all of whom have prior experience. Now I'll tell you, I'm answering my lady's second question.
Right.
You see, we all have prior experience. Some of us may have 3 years, some of us may have 6 years. So inter se in this category, if you even look at the rules, I may get 2 years for 1 year's experience. I may get 6 points for 3 years experience.
Right.
Now please see.
Of our application.
Now please see. May I just take you back? We are just on interpretation right now, not on merits. We're on interpretation.
Give a copy. Give a copy. There was direction for circulation of.
Correction, she is not even a party.
I am in items 9, 10, 11, 12, 14.
In 10, I have made him party.
Who have you served, madam? Who have you served? The councils are here.
There was a direction on the last occasion.
Yes.
Give copies of
Who
the
did you
affidavit of
serve?
service here. Give copies of the affidavit.
Who did you serve? The councils are there. Item 9, who did you
10,
serve?
10.
No, item 9.
9 and 10.
9. We are in
9
9,
and
10.
10.
They're identical, my lady.
Right, 9
9,
and 10.
10.
Who did you serve? If there is no service, then I'm not going to hear you at all. Show me.
This is the service.
Please, onake dekhan.
9 and 10.
9 and 10, check out whether service has been affected or not.
Okay, service.
If not,
9 and
please
10 are
hand over copies. Yes, madam.
Yes. So on points of academics and academic score, because the rule could not have said academic score. It has to be, it's a composite. It's just English grammar, my lady, nothing more. Academics has 2 components. So therefore, Schedule 2.2, the title, has to be academics because there are 2 components to it. Component 1 is educational qualification. Component 2 is the prior teaching experience. Both these are academics. If you ask my son, for instance, what are your academics like? What's your performance? And of course, he runs away when I ask him this. But it will be more than one. Math, English, PE, so on and so forth. What is your academic performance? What is your academic score? That is a composite. So it is only on English. It is not contradictory. Nothing needs to be read out. That's the first submission. Now please see the second submission. Please go to prior teaching experience, 10 marks. My lady has that, Schedule 2.2.
At the secondary level, in a government or government-aided or government-sponsored school, calculated on the basis of 2 marks for each year of service in a substantive post as permanent or contractual basis. So this could include those who are not part of the 2016 recruitment cycle. This could include those who are part of it. This could include those who are in government teaching positions, or this could include those who are on contractual positions. So
No,
the
it's
net
all
is
right.
very wide.
All said and done,
Yes.
this stage, you get the marks.
Yes.
What stage?
Now the stage. Now please go to Rule 11.
Yes.
Rule 11 makes it clear, and then I'll come back to 2K and 2L. Rule 11, my lady has this.
Yes.
In my compilation, it's 541, but be
I
that
have
as it. Method of SLST for selection of candidates and preparation of the panel. The method for selection of candidates. Now, please turn the page over. Please see the sequencing that happens. Rule 10, this is 11, subclass 10, my lady. Preliminary list of shortlisted candidates. Step 1. Thereafter, 11, regional commission shall verify the credentials. So at this point, I have taken the exam. I have given my educational qualifications, which are in academics. Please see, that is in schedule 2, academics. So at this stage, 11, there is a verification of schedule 2 that is happening. This is step 2. Step 3, 12. The regional commission during document verification in case of any doubt on disability. So any other specified categories, there may be other categories also. Step 4, so 3 continues. This is verification of documents. What documents? Educational qualifications. This is criterion 1 of academics. Now please go to 15. The central commission, the regional commission submits these report to the central commission. The central commission, after we have finished this process of academics, which includes educational plus prior teaching. Now step 3. After this, the Central Commission shall prepare a consolidated interview list, which shall be published and be forwarded to the interview board. After academics has been assessed, this composite list, step 3, is sent to the interview board. Step 4, the final step. After the interview board shall forward a detailed report to the Central Commission, which shall, from the interview list and on the basis of the report of the interview board, prepare and publish a merit list. This is the final stage. The culmination of 1 to 4 is step 5, which is the merit list, which, my lady, is L. That is the final stage. The rules are harmonious. We may have belabored its explanation, but the rules are in consonance with the steps which the rules provide for. It is in consonance with English grammar, and it is in consonance with the idea that a seminal idea which the Supreme Court has long upheld. It is within executive and legislative domain to fix qualifications. There is no preferential treatment here. We are choosing the best possible teachers. That includes educational qualifications, that includes prior teaching experience, that includes performance in the interview.
Very well.
I have a direct answer for your lordship's
Yes.
question. When it will be, my first point is it is absolutely clear when in the rule itself there may not be any requirement of any kind of interpretations. Kindly see first 11 Roman 8. Well, this is the substantive part of the rule. There is a difference between definitions for the purpose of finding out what does it mean and what is to be done. Now, what is to be done at 11.8, kindly look at two things, presence and absence. Presence of K and absence of L. So, 8 equals to, kindly, if I read, the Central Commission shall prepare and publish in its website a preliminary list with details of candidates to be called for interview. So therefore, pre-interview. So there is no confusion. Subject to verification of credentials, it's not relevant. And eligibility category-wise, on the basis of, now this is preliminary merit score as defined in Rule 8.1K. Lordship, conspicuously finds that it's not the definition of merit that is not there. The definition of interview list that is incorporated. And Lordship kindly come to straightaway schedule itself. Well, when Lordship's query is at what stage? 1 first, 2 second, 3 thereafter, 4, and that's the thing. Kindly follow that the simplest thing. Schedule 2, A equals to capital A equals to the entirety what is required to be done. It's not what exactly pre-interview, all. Now 1, 2, 3, 4. Kindly come 1. Exactly that was the beginning written, done. 2. Now 2 has 2 components. 2 has small a and small b. Now kindly see thereafter 3. So chronologically, this 3 for 9, 10 and also for 11, 12, it is coming after 2. If I just say once more, there is a clear chronology under the schedule. 1, 2, 3, 4. Yes, 4 ultimately ends at lecture demonstrations. So there, my lord, the oral interview comes as 3, whereas the prior teaching is coming under 2. So the question before your lordship is at what stage? It is at the stage of pre-interview because of the 2 reasons. Reason number 1.
When is the interview going to be held? Any idea, Commission?
Well, it has to be after the list is prepared.
That I understand. How soon are you expecting to prepare the interview list?
The verification process will go on for till 17th, 18th. I'll take
Till?
instruction and till 18th. I'll take instruction
Is
and
it after the 26th
I'll take instructions and
or before that? If the
tentative schedule will not.
Advertisement they have given, but
that is not being followed.
that is not being followed.
Assuming the Supreme Court interferes and says that 10 marks will not be there, as was submitted by Mr. Mitra on the last occasion, then the stage issue comes later
This
on.
stage issue, may I say?
Right.
I'll take instructions, sir.
May I just conclude? My lord, the stage issue can only come if there is any kind of confusion, as was sought to be said.
Now they are raising
Now
confusion.
they are raising,
issues.
correct, they are raising. I'm not saying that they are not raising, but once lordship look at from this angle, when it is clearly said as 1, 2, 3, 4, and 3 equals to oral interview, now then lordship has to somehow change this rule. I'm not saying that is impermissible, but that's a different thing altogether. As far as the
You say this is the chronology, they say that is the chronology.
no, I don't say the chronology is the only reason. I say this is the chronology. So the rule itself shows that before oral interview, it has to be calculated, number 1. And the direct answer is the substantive. The substantive says 11.8. I would be only praying before lordship to see the absence of L, because their entire submission is on the basis of definition of merit list. That comes later on. Lordship kindly see that in Roman 8, there is an absence of, so therefore how interview list has to be made, that is clear. Nobody is required to interpret it. They could have simply said, you also add the M. You also add the L. They have not. So where merit list comes, kindly look at Roman 16. Much after. And if your lordship kindly take the definition, it would be clear also. The merit list is something which comprises of everything if there is a requirement. It is not a double marking at all. Because for primary, that chronology is different for the prior teaching experience. That's they thought it. Kindly look at my lord, this K. So K is the clear answer. What should be the interview list? Number 1. And that says on the basis of the preliminary merit score. Now, where the preliminary merit score comes, is it before oral or after oral? Schedule 2 is clear. Now, their entire submission, if I take it, is they are banking on L. L equals to merit list. Now, if lordship kindly see a definition of the L, it is possible to say that there is a some kind of, if I say, contradiction, but that is contradictions in the definition clause, not in the substantive clause. Substantive clause 11 Roman 8 clarifies that this list has to be done on the basis of the K and K only. And in that context, assuming that, my lord, there is a confusion, there is a direct judgment that this judgment, my lord, takes this part. Kindly take the definition clause 2. This is the kind of rule which begins with 2-1. Kindly take, my lord, 2-1. In these rules,
I'll fix this matter later on. Please come. Heard submissions made on behalf of the parties, including the applicants' interveners at length. Stop. Release the matter once again on 28th of November 2025. Supplementary affidavit filed on behalf of the petitioner in the matter of Rahul Mondal and others
Let them prepare the list, but not for
be taken on record. Stop. Next.
যেটা দিল তখন না তো
In the last day's order, it has been recorded that the fate of the examination will abide by the result of the writ petition. That order remains. So that order continues. And just wait for the Supreme Court to make any type of interpretation, or if you all can get hold of any one line which says that this court can go into all these things, then with an open mind, the court can decide. Otherwise, it's always playing at the back of the mind that anything will touch that 10 marks.
Yes.
Anything, any order passed here will touch that 10 marks issue.
But this issue would never be gone by the Supreme Court.
Suppose the court says that the 10 marks will not be there at all.
That is fundamental.
That is the main thing. Then no question of former, later, now, later.
But if the Supreme Court says
Right, then this is there and the interim order is also there.
okay, give them that.
10 marks, they can always calculate. Let us
there is
see.
already an order to abide by. There is no reason.
Yes.
And this is not that kind of matter that they can seek a stay of entire proceedings.
Nothing of that sort.
On
Yes.
20th November, one clarification, will my lord hear me or not?
I will certainly hear you.
Then he will.
I have heard you. Today also I have heard you. And I'll hear you on the next day
I
also.
would have avoided all the complications.
You have, sir.
How to read a statute, that's the
Yes.
only question.
Yes, sir.
That's
Next day. Ek minute. 9. Yes, yes. For what? No, sir. You must be filing your intervention application. That is on record. What affidavit will you file? What affidavit will you file? Your application is in your support. What further application will you file? Don't add up documents. All right. Can যতগুলো আছে না allow করে দেন.
My lady, just one
The
small point.
documents to be circulated, did you interveners?
Yes.
What about the copies? Did you get it? Copies?
Yes.
Other cans?
I have not received.
See, somebody has not
please
received.
give
Please
copies.
give. Please give.
Don't be stingy on photocopy.
To avoid
Copies.
They involved the 4 matters, my lord. All the matters we have solved, and I have the affidavit of this matter.
See, the court is not concerned with the affidavit.
My lord, any of the matters.
The paper should be there. The court is happy.
Hand
the
over.
question of law.
Copies.
But to avoid further confusion, logically record note, this issue does not relate to the constitutional validity, but relates to the applicability of the rules.
Last day's order, what is the issue is clearly recorded. I will not add anything.
My lady, my submissions are for all the cans that I'm appearing in, my
I'm a
lady.
very
So you file it today, you file it on the next day, it will be the same thing.
Yeah, so it's the same submissions for all of them. We've got them very briefly for my lady's consideration.
Give it, it is the same thing.
Yeah, it's the same thing in all the categories.
Same order will go down in item number 10.
My lord, only one thing, your lordship is allowing these
9, 10,
applications.
11, 12, 14.
They'll
Then,
let
my
it
lord-
be added because I'm hearing them.
Yes, my lord, only one thing, then department may be directed to amend the cost title because
cost title amendment করবে intervention
Right now,
এই হিসেবে
intervention হিসেবে থাকছে
let them remain. Let them remain. They have been allowed to participate in the proceeding.
My lord.
The court has heard them.
Yes.
Right?
My lady, I hope I'll be able to come back to my lady's court.
Please
Hopefully,
do.
That's
And
my,
enjoy the city.
that's my hope. Yes, I'm
It's
grateful.
a nice weather right
Beautiful
now.
city.
Please do.
Grateful.
আমি জানি না
Take the item number 5.
5 and 6. These SSC's matters are over, isn't it?
There is only item
Oh.
13. Similar thing with different.
13 has been marked. 13 is the same thing.
14. 14 is
14 is
B and group C.
13th has been already fixed. Order হয়ে গেছে তো 13 তে? 13 হয়ে গেছে। 14 I 14
13 is different.
14 is
14 is my lady.
না দাঁড়ান দাঁড়ান
14 is segregation within the class.
There's not be challenging.
which one? 14?
14.
Who are the applicants? Please check up. Give a phone call. Then serve
Can
copies. Please serve.
I want to argue because this is whether we are for the unlimited teacher of 11, 12. I am glad. But the rule is specifically qualification and mode of selection is the different. So, whether
Can number 1.
is eligible, but the teaching experience marks for the 11, 12. They have applied because one of the rule is there, but there is the two categories. If the 9, 10, one of the untainted teacher applied in the one of the 9, 10 school and 11, 12, if the marks will be given for the both, so double benefit will be given. That is our contention. We are the untainted teacher for the 11, 12. So, my lord, the rule is the.
You do not want the 9, 10 teachers' experience to be counted. Or 11, 12.
Because the rule is the different and education quality is the difference and selection process is the different. So, my lord, school service commission, what is the stand?
All right.
There-
Let us wait and see whether the Supreme Court upholds the 2016 rules or the 2025 rules. If the court upholds 2016, then all goes. If 2025 is upheld, then the court will look into all these things.
One thing is, my lord, they kindly recorded my submission and my lord, if the my lord, the 19 my lord, the teachers will get the benefit for the 11, 12 course because my lord, they will get benefit for the one class. If they will be benefit for the two classes, but double benefit will be given. But that is not permissible under the law.
Listen. A candidate will get one selection either in 9, 10 or 11, 12. Right? Now you say that their experience in 9, 10 cannot be counted for 11, 12. This is exactly your
An
submission.
application there
That's
also.
because
Right.
they are the untainted for the 9, 10.
We are right now not in tainted and untainted. Right now, the issue is whether 9, 10 qualification can be taken up for consideration for teaching classes 11 and 12.
Because they have no experience in the 11, 12.
They have no experience in 11, 12. Item number 14 এ একটা order লিখুন তো।
হ্যাঁ স্যার এটা তো
The-
আছে আমরা
Petitioners raise an issue
But I also have an application.
with regard to the
অর্ডারটা হয়ে যাবে
selection process initiated by the West Bengal Central School Service Commission for appointment of assistant teachers in accordance with the rules and নামটা একটু দেখে নেবেন তো 2025 rules. ঠিক আছে? Submission is that the
মেনশন করেছে
authority cannot take into consideration the experience of candidates teaching 9 and 10 for recruitment in classes 11 and 12. This exactly is the issue.
But I have can two.
I have can 1, item 14.
All right. The broad issue as to whether the 2025 recruitment process can be adopted for the recruitment or the 2016 rules will apply is pending consideration before the Honorable Supreme Court. Stop. It has been brought to the notice of the court that the matters are fixed before the Honorable Supreme Court on the 24th and 26th of November 2025. Stop. Next. Let this matter be posted on 28th November 2025. Stop. There are several intervening applications in the instant writ petition. Stop. Let copy of all the intervening applications be served upon the learned advocate representing the petitioner. Stop. The copies of the applications shall also be circulated amongst the parties. If served, then there is no reason for double service. Just ensure everybody has all documents, nothing more. Yes. Yes.
Only one line in your lordship order.
Which order?
The last
14.
just one. Whether 2016 rules or 25 rules, there are other issues also, just add, if it comments to your lordship.
Where?
In your lordship
Matter.
order. In the Honorable Supreme Court, all issues are covered.
Whatever is there before the court is
Your
there.
lordship is been pleased to record, whether this rule or that rule.
Yes.
That particular
That will cover everything. No, nothing. 5 and 6.
has not been challenged before the Supreme Court.
Yeah, that was the submission I have recorded.
25
in the-
rules specifically is there.
Yes, item 11 to hoye gache.
And item 11 will be the same order.
Yes.
13 is
Only item 13 it will be different because it is for group D and C. Which is group D and group C. Here it is not a teaching experience, similar experience. Now, so therefore, this is not there before the Honorable Supreme Court. But I don't know whether Lordship wants to hear it now or
Item 30.
item 13. There is a separate rule.
The counsel for the petitioner agreed to pass the same order in respect of 4, 7 and 13 has been tagged.
Done so incorrectly because
Then if the petitioner has done it incorrectly, let the petitioner do it. Let it be.
the only thing there is
Kanta.
there is an addition in the party in item 30. If there is a one line in that.
Can 1, 2 is there.
I appear for the can 2. আমরা can 1.
Can two.
Can 1 আমাদের।
Can one.
Application of addition of party. Item number 13. আচ্ছা 13 এ একটা লাইন লিখে নিন। The
Different rule. Not the same.
learned advocate representing the interveners have been heard. Stop. The interveners will be heard on the next day also. Yes. All
This is the affidavit of service, my lord.
Yes.
This is a question of, my lord, the higher scale of pay. The petitioner first has been appointed, my lord,
5 and 6. Only 6 here.
in a
Other side
school.
is there. Other side is there.
Item number 5, my lord, Mr. Biswajit Dey is appearing. He is engaged in another courtroom, my lord.
My lord, your lordship kindly take this matter up at two. Both
One
these
minute. 1 minute.
6 years. 6
This
years.
is so 118. It's past recess. The courts are sitting. We
Yes,
come
my lord.
just now. What is the matter?
My lord, petitioner, my lord, after getting appointment in a school under the Bardhaman, my lord, thereafter he passed, my lord, the MA examination. And my lord, thereafter he seeks,
Postgraduate scale of pay. Where is your application?
my lord, there is 2 applications, one in the district of Bardhaman and thereafter.
Has it been considered?
No, my lord.
No.
Thereafter she has been transferred to the Howrah.
Yes.
And my lord, thereafter he again made an application before the district inspector of schools. My lord, let it be considered,
Page.
my lord, prayer for, my lord, that is page 57, the last application.
The petitioner
My lord, within
higher
the
scale
time
of
bar.
pay. Stop. Her application seeking higher scale of pay is pending consideration before the District Inspector of Schools,
AC Howrah.
Secondary Education, Howrah. Page 57.
Yes, my lord. Annexure P21.
I have got only 56 pages, but your application is here. Acha. Without entering into the merit of the same, the instant writ petition stands disposed of by directing the District Inspector of Schools, Secondary Education, Howrah, to consider the petitioner's prayer in accordance with law and in line with the judgment laid down by the special bench of this court in the matter of Utpal Kanti Koron and others versus State of West Bengal and others, reported in 2024 SCC Online Cal 1274. At the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. Now I take it 12 weeks. Korun. An opportunity of hearing shall be provided to the petitioner for production of all documents in support of her prayer. Stop. A reasoned order shall be passed and communicated to the petitioner. Stop. If the prayer of the petitioner is allowed, comma, then necessary consequential steps shall be taken by the said authority. Disposed. Service is taken on record. Yes. Next one is also same.
No, my lord. This
Different.
is
What is it?
my lord, this is, my lord, regarding, my lord, the CPF to GPF.
Yes.
My lord, the widow has come to before your lordship because, my lord, the pension, my lord, has been
You
given.
got similar order?
My lord, I have the.
Please give.
My lord, it has also been corrected in my way.
All right. Who are you for the state? All right.
আমি তোকে একটা কথা correction করে দিই।
From the date of
There are similar orders for widows also.
from the date of
My lord,
return.
I have corrected that wherein the husband, I have corrected the widow. Every page I have corrected. I have carefully corrected.
আমাদের কাছে widow আছে CPF GPF widow.
From the date of retirement.
My lord, from the date of retirement, he paid for date of retirement. That was not paid to the original petitioner. Original, my lord, the pensioner.
এখানে একটা দিয়েছে আমাদেরটা দেখে নেবেন আর এটা দেখবেন সেম হলে দিয়ে দেবেন ডিসপোজড
Grateful. Of service in both the days.